Can a defendant challenge a plea on the basis that the jail won't let him go? To find out, you have to read People versus Laboriel, but it's 14 pages. Don't have time for that? I've got you covered. DR, too long, didn't read. New York Court of Appeals cases in 5 minutes or less. This is the episode on People versus Laboriel. This can be found at 2022 New York Slip Opinion 03863, published by the Court of Appeals on June 14th of 2022. This is a criminal case, and the issue here is whether a defendant should be resentenced if the terms of the plea bargain are violated by the Department of Corrections not releasing him as per the terms of the plea bargain. This is a situation where the majority issued a memorandum opinion, one paragraph, that's it, saying this is really not appropriately before us. The appellate division addressed whether it was an excessive sentence, and it was not. So as a matter of law, we shouldn't address this. But the dissent, which is by Rivera and Wilson, goes deep into this. And the facts here, well, the law here, to understand the law, there's not much law. Basically, the law you have to understand is basic fairness and essentially what a plea bargain is. A plea bargain is a deal between the prosecution and the defendant whereby the defendant agrees to plead guilty with an agreed upon sentence, and in exchange, the people take that plea and they don't have to then put the defendant, they don't have to burden all their witnesses, burden their cops in, go through all the added expense of proving the defendant guilty beyond a reasonable doubt before a finder of fact, before the defendant is found guilty and then serves a sentence. So there's a negotiated plea where there's, the people are getting less time than they probably would be asking for if they had to go through trial, and the defendant is pleading guilty and not putting them to their proof. In this particular case, the facts here are the defendant pled guilty and with a promised sentence of 3 years jail and 5 years post-release supervision. He served his 3 years jail. And what you have to understand here is that when a person pleads guilty to state time, right, to upstate time, they serve 6/7 of their time, and they get 1/7 off. They get Sundays off, good time. So they're eligible for conditional release after they serve 6/7 of the sentence. In this particular case, 3 years jail. The defendant would serve 6/7 of the 3 years and then be eligible for conditional release and then post-release supervision. When it came time to release the defendant, after his good time was served, the Department of Corrections and Community Supervision, which is DOCS, which is the agency that runs the jails in New York State, they said to him, okay, where are you going to live? Because he was convicted of a SARA offense, of a Sexual Assault Reform Act offense. So when you're going to leave jail, you have to tell them where you're going to live, and that address has to be more than 1,000 feet from any school. So he gives an address. DOCS returns back and says, no, that address is no good. It's within 1,000 feet of a school. So they won't release him. He then stays past his max expiration date, which is July 2nd, 2020. Then they transfer him to a residential treatment facility in Fishkill Correctional Facility, which is a medium security prison, for 9 months of his post-release time. He's there for 9 months and eventually he gets out. He appeals while he's at the residential treatment facility of Fishkill, asking the appellate division to reduce his sentence or his post-release supervision time because he's in jail longer than his deal was. He files a writ of habeas corpus, basically saying I'm being held illegally, in illegal detention, and he says that there's a violation of my substantive due process because they're not helping me find a SARA compliant address. They're not helping me, or they're not putting me into a shelter because I want to go into a New York City shelter. As I said, the majority opinion says it's a legal sentence. It's a legal sentence, and everything after that's beyond the scope of what we are addressing. But the dissent says this is a problem because the defendant made a deal, and his deal was, I will plead guilty and I will serve this amount of time in jail, and he's being held beyond that amount of time. So according to the dissent, there's a problem here, and the government's not keeping their word, and they're part of the bargain. And why are they keeping their part of the bargain? Because of SARA, because of that 1,000-foot rule, because Docs applies that to the homeless shelters that they run, and they only permit 10 inmates to leave per month into a homeless shelter. And the dissent says that the fact that New York City shelter system has a side deal with Docs should not prevent the defendant from being released, and as a result, the defendant should be allowed to be resentenced to a reduced prison sentence because he's spending all this time in jail when he shouldn't be. And that's Too Long Didn't Read, People versus Laboriel. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.